Okay, to keep the trains moving on time, I'm going to get started here. So my name is Andrea Matwyshyn, and I will introduce myself a bit more on the next slide, but I want to thank Jake and the organizers for inviting me here to speak with you. This presentation is a preview of a paper that I'm currently completing called Cyber, all caps, exclamation point, ironic title. So, who am I? I am a law professor and a psychologist, and I have an honorary joint appointment in a computer science department. So I teach at Northeastern University, and I'm affiliated with Princeton Center for Information Technology Policy, so I get to hang out with brilliant computer scientists, and also Stanford's Center for Internet and Society. So I've been hanging out and speaking at HackerCons since 2003. Black Hat 2003 is my first talk, and it's been a privilege to be part of this community and to observe the interesting changes that have happened across time. As many of you know, one of the major changes that's happened is that the policy world and the legal world have become increasingly interested in the security issues that this community has been thinking about, talking about, and researching for 20 plus years now. But as you know, from especially living in the DC area, cyber is the cat's pajamas and the hotness of the last few years. And it's partially because of that, what might be called kind of moral panic around security, that I've opted for the stylistic choice of Comic Sans for this presentation, just to give us a little bit of critical distance from the issues. And so this is really a critique of the conversation from an outsider's view, not so much of this community, but about the dynamic between my world of policy and law and the research that's going on. The other piece of this that I should share with you, apart from having the privilege of talking to groups like this and legal groups, I started my career as a corporate lawyer in the 90s representing tech startups and multinationals as well, as they tried to first engage with the emerging body of law in the late 90s around the internet. And it was a wild and woolly time. Some of the conflicts we've never resolved, and that's part of what's making the conversation around security today so challenging from a legal standpoint. The other item that I'll tell you guys about myself so that you have a sense of where my perspective's coming from, I served as the Federal Trade Commission Senior Policy Advisor on security and privacy for a year. And so that gave me the privilege of interacting with some of the enforcers as well. And as many of you undoubtedly know, the FTC is probably the leading agency that's most engaged with security enforcement, to the extent that an FTC commissioner is going to DEF CON for the third year in a row this year. And the FTC has even run contests at DEF CON. So that is a very high level of engagement for a federal agency. And so it's with that backdrop that I'd like to share some thoughts with you about the way that the security conversation is happening. And this is my plea for leadership from this community in definitional specificity and in self-governing standards to help guide the policymakers in a collaborative way. So I don't need to tell you guys that unfortunately our ecosystem is still rife with vulnerabilities and that things are only becoming more dramatic in many ways. So I was just at Privacy Law Scholars in DC. There's a law professor conference going on at the same time, and yesterday I presented a draft paper of mine called The Internet of Bodies. And I introduced the ideas about the extent of medical devices and other enhancement devices that are being connected to the body and through Bluetooth and through the internet, et cetera, exposing consumers, people, to new security risks and how that interplays with our traditional legal frameworks, punchline, poorly, right? There's a lot to be done. But bringing in that medical device vulnerability conversation that has been robust in this community forever into a different audience, that's part of the challenge that we face, the grand we, as we nudge this whole security bundle of issues forward. So when I give this talk to legal audiences, I use this slide to bring them into the fold a bit, and I introduce two movies. I introduce the interview, of course, and talk with them and try to connect with them with respect to the conversation around attribution for that series of incidents, the conversation about good vulnerability practices on the Sony end as well, and how those two play together. And I also tell them a little bit about the movie Black Hat, which fewer of them have seen, but nevertheless, I mentioned that there was a group of people at ShmooCon, where I happened to be when Black Hat was premiering, that went to see the movie, and so I share some of the observations of that audience. And part of the challenge for me, and I think for all of us, is to create those communication bridges. So with that, let me take you to kind of the next step in this conversation. And I'll only speak for about 30 minutes, and I really would prefer to open it up to questions so that we engage together on this. So basically, legally speaking, there are two dominant legal paradigms that are pervading the DC conversation from my perspective. The first is information sharing, which is useful, but as you all know, we still have some building blocks that are missing to be able to construct the conversation around information sharing in a robust way. You know, the experts in this audience are in a better position to articulate those building blocks than I am, but for example, making sure that the CVE system can scale, making sure that our severity assessments for vulnerabilities fit with the Internet of Things and with emerging new categories of threats. Those kinds of scaling and other challenges, that's something that this community is best situated to do, not the legal community. But in order to have meaningful information sharing in the policy sense and the legal sense, those underlying building blocks of standards and more robust structures of enumeration and severity rating, et cetera, they need to be in place, or there's this false perception that just information sharing on existing things as people are compromised is somehow enough. We all know it's not, right? And so helping policy people understand the difference between good security practices underlying this information sharing and the metrics that we still need to build to a greater extent, and why we need government funding and help in facilitating the creation of those organizational collaborative relationships as a precursor to information sharing. It's something we're currently missing. The second paradigm is deterrence, and this is old school criminal law. Criminal law is predicated, perhaps on more than any other paradigm, the notion of deterrence. So every first-year law student will tell you that there are 4 purposes of criminal law, and depending on with whom you speak, you'll get a different kind of supremacy of which of these purposes is most integral to the functionality of our society. So deterrence obviously is the idea of scaring people into not doing the thing that you're identifying. But there are also values in some criminal laws in non-internet contexts that display elements of retribution, revenge, incapacitation, just taking people out of society, and also rehabilitation, helping people to think through their conduct inside the construct of the rules and to help them evolve to conform their conduct to the rules. Right now, with respect to security, we have the attempt of the deterrence paradigm being supreme. So when you look at the conversations around hacker prosecutions, we have the rhetoric of deterrence happening. But as we know, that's a little bit of a square peg round hole because of the way that security threats emerge and the way that information criminality happens. And so that framing is also presenting a challenge because the way that different agencies are approaching security is varying partially because of that paradigm that's being used or not used and with respect to deterrence. And I'll talk a little bit more about this later. So to flesh this out, I'd like to identify 4 flaws that I see in the conversation around policy and security. And the goal here is to share these observations with you, partially to help you as technical experts in this area engage meaningfully with people who are not technical experts in this area, and to connect with some of what lives in their head, or they've read, or they've seen around the topic of cybersecurity. So the first flaw is the fault of my world. So particularly among lawyers and among law professors, the first flaw that I'll identify is something I call privacy conflation. The field of cyber law, as internet law was called in the 90s, was followed up in popularity by privacy law, so internet privacy law. Security, with the exception of a few of us who kind of were maybe ahead of the game because of the fun of hanging out with you guys and learning from you guys, with the exception of a few weirdos like me, the majority of law professors who think about security now came to it through intellectual property law or through privacy law. And so, as a result, the default framing for many of them is trying to frame security as some subfield, subsection, how it relates to privacy. But that's not a fit. Security is a different thing. So the way that I try to draw this line, and that's what this paper is primarily doing, is to try to articulate some of the division that exists within computer science. So in privacy, and even if you think about the way privacy policies are constructed, we're talking about individual end-to-end relationships where people are trying to transmit information in the way that a particular individual wants to another particular individual endpoint. So it's about the relationship of individuals to the information transit and each other. Security, as I frame it in this paper and for policy people, is about the properties of systems. That means that while your privacy policy may be a negotiated, mushy construct that's a contract between the company and the consumers, for example, with security, a system either possesses integrity or it does not. It either is available or it is not. Now, we can talk about the degrees of acceptable problems in security, but obviously the objectively testable reality of whether a system and code possesses these characteristics that demonstrate state-of-the-art security is an objectively testable proposition by third parties. Privacy questions are not. They're inherently situated within a social conversation, construct, and contract. Security is something different, and by splitting those apart, we can start to create a more robust conversation on a policy level with respect to security. Okay. Second, incommensurability. So you'll notice that I say security, I'll say computer security, I'll say information security, I'll say infosec. I don't say cybersecurity unless I put air quotes around it or for the sake of a proper identifier. Why? This term, cybersecurity, means different things to different people, especially in policy spaces. So what is happening is an incommensurability problem. When a computer scientist is trying to connect with a policymaker and uses the term cybersecurity, that term may mean something very different to her or him than it does to the lawyer hearing that term. And this is a problem because we're not building the shared understanding of technological reality without being specific about what we're talking about. For example, it is more often than not the case that when you hear a newbie to security talking about cybersecurity, they're not necessarily considering the importance of the physical side of it. They're not thinking through the extent to which having physical dominion over a box means that there's a problem, right? You can compromise information in ways in physical space, whether it's through actually attacking the hardware or through humans, right? Social engineering, core skill set of attackers everywhere, and the security researchers who seek to prevent the attackers. But when we frame this conversation around a cyberized paradigm, we sometimes forget that physical security component, or at least some of the policymakers that interact on these topics may forget that. And so, again, specificity in the conversation. Some computer scientists, as I'm sure you've noticed on Twitter, and some members of this community as well, get frustrated with the cybering of the conversation. And William Gibson has even said, you know, cyber was never intended to mean anything. We have cyber cars now. We live in a cyber world. We have cyber fridges. When everything is cyberized, what's the point of throwing that prefix on all the things, right? And so, again, this is a sign that perhaps we can more specifically reframe our conversation to more rigorously and more technically engage in what it is that we're trying to accomplish as a country and as a community, and trying to push forward national security, corporate vulnerability mitigation, and our own consumer protection issues. Third, internet exceptionalism. So apart from the topics that I've already mentioned, there is this idea that perhaps this field is somehow disconnected from everything that came before. But that's, of course, precisely contrary to the way that attackers work and the way that security works, because it's all embedded within a bigger picture construct. And one of the elements that's perhaps most troubling to me in this series of flaws, and it goes to the incommensurability problem even more probably than this one, is that we're at the point where we have different federal agencies talking about security in potentially contradictory ways. You know, for example, the FBI is very concerned about end-to-end encryption. The FTC thinks encryption is an excellent method of data security. And so that policy conversation between those two agencies, and more broadly, is implicating all of us in multiple contexts. But, you know, we're all wearing many hats, right? We're a professional, we're a citizen, we're a consumer. And so having these definitional cross currents working against each other in some cases will not lead us to the optimal outcome in terms of crafting a big picture policy for our country and innovation in the next generation, and national security too, right? Unless we get these building blocks in place and create common understandings, we're going to continue to see agencies who are all well-intentioned working at cross purposes. Okay, and the fourth, as I promised there would be bacon in this talk. Here's the bacon. So, many of you are undoubtedly familiar with the saying that everything's better with bacon. And part of the challenge in the conversation is that sometimes there's a presumption that more technology is better technology. That the shinier the gadget, the more buttons there are to push, the more complicated the code, the newer, more innovative, more air quotes, the better this technology is. And this is something that we need to really take a step back and realize that that's not always the case, and it's important for policymakers and to help policymakers recognize this. So the same way that while for a highly carnivorous meat eater, having dinner arrive with an unexpected, undisclosed, ample sprinkling of bacon on top of your meal may be a joyful bonus. But now, let's say that that eater is a vegetarian who chose that meal specifically because there was no disclosed bacon on it, right? So it's a question of whether the technology is optimally suited for the purpose for which it is intended. So let's take a SCADA system, let's take a nuclear power plant. Do we really want our nuclear power plants that were constructed a long time ago to be forced to work with some sort of a mobile interface so that the lead engineer can adjust settings from the comfort of his sofa in between, you know, his favorite show's commercial breaks? Is that a reasonable risk trade-off? Thinking through the fit of the technology, even if it's an older technology, for the risk profile of the situation is something that we're not currently doing very well in policy situations in many cases. So helping think through this better with bacon problem alongside and helping policymakers think about this, it's something that even in just your casual conversations with your friends who are not in this field, it's the way to get viral spread of good ideas around security basics. Okay, so here's my kind of shifted paradigm that I'm sending off into law world and policy world, and maybe it'll resonate with someone. I hope it'll resonate with someone, but it's a bit of a reframe from what's happening right now. So I call this approach a new security paradigm of reciprocal security inducement. So this approach, from my standpoint, I encountered the philosophy and science theory of this philosopher of science who was also a scientist himself, and he was sort of a multi-talented guy, though his older brother is more famous than he is. His older brother is Carl Polanyi, but this is Michael Polanyi. And Michael Polanyi wrote a number of really interesting texts about how to help scientific advancement intersect and function within social constructs and legal constructs with economic concerns. So he tried to create frameworks that blended all of these dynamics. So from Polanyi, the idea to take away is, there are a few subpoints. So the first is for Polanyi, this is all like working on a huge 5,000-piece puzzle in a team. You're not creating a hierarchy of conduct. You're creating a group of people who are working together in a loosely coordinated manner. Each piece of that puzzle, each group of pieces, each section that's being worked on is needed for the completion of this puzzle. And if one group falls dramatically behind, the puzzle's not going to get done, or it's going to get done wrong. So what needs to happen is that as each group works on each corner of this puzzle, they need to loosely coordinate across groups to make sure that everything is working together as a whole. So he views this kind of a multifaceted problem as the typical kind of structure that we see in complicated science, technology, economic, interwoven problems. So that's point one. Think of this as a giant puzzle where we need to loosely coordinate, help each other to get all of the corners built correctly. Now, the second piece that he highlights, in particular because he paid attention to judges and lawyers in his scholarship, and he's a philosopher from early last century, if memory serves. So what he highlighted was that both technical communities and legal communities have deep structures of tacit knowledge, implicit communications, structures, definitions, terms that they understand among each other within their group, but that a lost in translation feature can happen across those groups because the knowledge communities of lawyers versus technologists, for example, have different structures of tacit knowledge. If you've ever heard two first-year law students geeking out about civil procedure jokes, it's very special. You'll know what I mean, right? They're referencing obscure rules with obscure twists and making an inside joke about some case. You know, if, for example, if I throw out the word pennoyer, it would, if I randomly threw out that word in the middle of a law talk, I would make the whole room kind of look at me like, what, and then burst out into hysterics. But it's an inside reference, right? The same way that in this room, you have a common language. And so trying to bridge those tacit knowledge gaps, that's part of the challenge of the puzzle building. So those two notions, let's grab that from Polanyi. And the third one is just a simple paradigm shift in terms of viewing the adversary's perspective versus your own. And for this community, this is a no-brainer. Obviously, you think like the adversary. It's the only way you can anticipate, right? But this is something that's novel to people who are outside this community. because they're not used to necessarily putting themselves in the position of the adversary in the way that they're building their structures. They're optimistic and hope for the best where everyone plays nicely kumbaya. But as we know, that's unfortunately not the world we live in. So one way to think about this, the Monty Hall problem, I'm sure most of you know it. It's this thought experiment where there's Monty Hall, who was an old school game show host, and you're asked to pick one of 3 doors, and behind one of the doors is a car, behind the other 2 doors there are goats. Now, footnotes, this assumes that you want the car more than you want a goat, which wouldn't necessarily be true for me, but let's not go there. So let's assume you want the car. So you pick, you pick your door, and then Monty reveals one of the goats. And then Monty gives you the chance to change your door. So for most people, they think, well, you can change, you cannot change, it's 50-50. But the math indicates that that's not the case, that in fact you should absolutely change. So the math there is very, it's a trust-oriented exercise, especially for policy people and lawyers. And so for me, another way to think about this and to help reframe the view into an adversarial mindset, which is something we obviously need for security, is to help people think about it from Monty's perspective. So Monty is choosing to reveal a door, knowing which door you picked, and knowing where the car is. So Monty is an oracle, and Monty may, not necessarily, but may be steering you away from the door that has the car. So Monty may be transmitting additional information. And if that's the case, then absolutely you should switch doors, right? So by viewing the exchange from Monty's perspective instead of the contestants, the world looks different. And so it's that adversarial perspective taking that's something that policy has not always engaged with well. The last point, undoubtedly you remember and still encounter instances where members of Congress might say, bring in the nerds, or get a nerd consult. And so a small group of technologists will be brought in and they'll be heard out, and then they may or may not be ignored. So one of the pieces that's critical to this puzzle is not only for the policymakers to embrace the realities of the scientific community in security, but also the other way around to help from the perspective of the policymakers for the security expert community to know where the policymakers are coming from and help to build those bridges in a shared discourse, and recognizing that each group has tacit knowledge that is equally valid but very different and needs to be harmonized in order to move forward. Okay, so the punchline of the reciprocal security inducement paradigm is precisely this kind of a self-reinforcing virtuous circle. Security is ultimately not that dissimilar across the private sector and the public sector, right? There are security basics that need to be in place regardless of whether you're a public or a private sector entity. Highlighting those security basics and making sure that an OPM breach doesn't happen again, for example, or a Sony breach is mitigated, or any one of a, take your pick, insert large name of company here breach, right? So helping to create a conversation across both the public and private sector of the underpinnings of what good security is in a way that's mutually understandable and everyone's on the same page, technically speaking. That's the first step in building additional levels of information sharing that actually work. And so the point is to help induce in practice good security by helping others lead by example, and yourself leading by example within each of our organizations to the extent we can do that. And viewing this all as one big puzzle and cooperative coordination while working independently helps us potentially to get there. So instead of the current information sharing paradigm, let's try to maybe reframe this as building a security vigilance infrastructure. Think about those underpinnings, those building blocks that we're currently missing to get meaningful metrics in place to help people talk to each other more clearly about precise security challenges that exist, with the ability to determine what really is a more serious challenge. But for example, when we have large portions of our economic infrastructure relying on open source products, and we don't have clear means of funding in place to help secure those open source products, Batman, we have a problem, right? We have to think about how to prevent these things from breaking, or there are going to be, fire drills of engineers running down halls screaming in ways that were avoidable. And the policymakers don't necessarily even know about these lower level problems on the ground that are plainly obvious to this community. But helping to identify those absent building blocks is something that I would ask you guys to engage with. In particular, as you all know, there continue to be repeated controversies about security vulnerability disclosures and about ethics in the way that vulnerabilities are probed, handled, verified, shared, et cetera. It's not the best place for the lawyers to be coming up with those norms of best practices. It's researchers themselves who should be taking the lead in specifying when, as a group sharing tacit knowledge, you believe that someone has proven something demonstrably enough, and when, pulling a million records to show the existence of a problem is too much, or is it ever not too much? How much is needed in terms of demonstrating the existence of a problem? Having that conversation and creating that set of standards in the way that many years ago, I can't even remember what the date on this is, but IEEE started doing some standards work, thinking through these kinds of standards about best practices in security vulnerability discovery processes. It will help to have a data point to then take to policy people and say, look, here are some guidelines of what the community of people who engage in these discovery processes view as best practices and reasonable conduct. Depending on how close a particular set of facts falls with that, it provides some guidance about whether, for example, CFA prosecution is appropriate or problematic, right? But the absence of these benchmarks, it's an information deficit that prevents building these kinds of structures that facilitate security in meaningful ways. The second piece is defense primacy. While it is certainly more exciting and more fun for many people to attack rather than fix existing flaws, there is enthusiasm for building next generation offensive tools. When we haven't fixed the basics of low-hanging fruit problems in security, when patch cycles aren't being implemented correctly, when there's still a severe deficit of even knowledge, particularly among medium and small-sized businesses, among government agencies. It's the analogy that a security researcher once used with me. It's like sitting on a haystack holding a flamethrower and pointing it outward. At some point, some of the sparks are going to come back at you, and you're going to find yourself sitting on a flaming haystack. And the goal is to avoid that, right? So making sure that we focus on defense primacy before we take those next steps offensively, and thinking about funding decisions and the way that we nudge our policymakers is something else that this community can certainly be helpful with. So apart from the various information gaps that I've identified and that you guys are in a better position of identifying in some ways, there are some translation data things that aren't happening. For example, it would be useful for enforcement of the suboptimal actors in securing their systems. If, say, the SEC filings that companies are making are easily cross-referenced with their vulnerability histories, right? There's this knowledge community of security researchers and security journalists who push out fantastically useful information about who has what kind of a security challenge currently going on, but that knowledge does not necessarily make it to the lawyers who are reading SEC filings at the SEC or who are drafting those SEC filings on behalf of the companies. Creating technology tools, and this is not on me, right? I can't build this, but you guys can. Creating technology tools that marry those data sets on an ongoing, useful kind of way, that would be helpful to enforcement. It'd be helpful to consumer education so that consumers start choosing and rewarding companies who invest in security by buying their products. And it would identify the kind of problem actors who have long histories of severe vulnerabilities that are entirely avoidable, and to spotlight them for enforcement where appropriate, right? So some of those kinds of coordination issues are readily available for nudging forward this conversation, but they're not something that the agencies can necessarily do themselves. And it's a side project for a helpful security researcher or six that may want to help with policy matters. Wholly apart from taking the time, taking a year off, taking 2 years off from your awesome, highly lucrative career to go work in government for a bit, just to share your knowledge, consider it an act of patriotism. That would be really helpful. If each of us did that, it would meaningfully, materially improve things, because that kind of informal knowledge transfer from the inside is something that can't be replicated externally. So that's my plea for public service right there. And in conclusion, no cybers were hurt in the writing of this article, but lots of memes were, definitely. So anyway, there are a few thoughts on where I see security policy going and some of the elements that we can collaboratively nudge forward, and I would be thrilled to engage with questions and discussion.